Good morning, everyone. We're just waiting for a few more folks to come in from the waiting room. I see them trickling in, but I think we'll get started on the introduction while we're waiting for the rest of the folks. I'm Lisa McMahon. I'm with Ken Hare today to answer your questions. A reminder that we prefer you'd stay muted to kind of prevent the background interruptions if possible. Feel free to submit questions you may have in the chat function of Zoom. We are a little bit late today on questions, so we may have time to answer. So if you have burning questions, go ahead and throw those in there. Reminder that we are not here to give you legal advice. We are just talking general legal information. So make sure that, or just understand that this information is not intended to be legal advice. And to that end, any comments or things that are in the chat are also not legal advice. Couple reminders that we've been mentioning. Number one, the CTA, or the Corporate Transparency Act, is still being challenged by the National CAI and is on appeal in some courts. So we are currently recommending that folks wait to see how that shakes out, if there's still going to be requirements, or if there's going to be any delay in reporting at the end, near the end of the year. So I'm still recommending people hold off if they can on complying with the reporting under that. Another reminder, we've had a lot of conversations about WUCIOA for All, everyone's calling it, that takes effect in 2028. But we did want to make a reminder that there are some changes to WUCIOA as it is right now that are going to be taking effect this June 6, 2024. So if you are a WUCIOA community, you should be aware that there are some changes coming your way in the next month. The revisions aren't yet on the legislative website where the statutes are. They're in the actual bill themselves, but they'll, depending on how timely things go, they'll roll out eventually. We will, if we have time permitting at the end, we'll talk about some of the changes that may be coming your way, things that have to do with records, some voting issues, but we can talk about more about that at the end. And then, of course, as things, when things change, we can talk about that as well if you have questions. Anything I missed, Ken, that you want to add before we get started?
No, I think you're good for now. Thanks.
Okay. First question. Can a board legally ask a prospective board member who is running for a position if they have been convicted of a felony in the last 10 years? The reason being, maybe they're screening for possible risk for candidates they're running in the election. And the short answer is probably not. You can ask, but the owner doesn't necessarily have to respond. And unless you have qualifications that are set out in your bylaws or in your declaration that require someone to report that to serve on the board, you probably wouldn't be able to do anything anyway if they did have some kind of a conviction. It's not really the association's job to enforce laws or to penalize people who may have served a sentence or I guess paid their debt to society for a previous thing. You know, I think there's a question about what kind of felony you're talking about. Also, we're talking about financial crimes that may be more relevant to an association, but without the requirement to provide that information in your governing documents, I'm not sure that that's going to get you anywhere if you have that information anyway. You could certainly create those kind of requirements in your governing documents. That would require an amendment by the membership and voting by the membership for those things. If you're talking about changing your declaration, I don't know if potentially you're talking about insurance questions, whether someone has a history and whether your insurance company is going to insure them for a financial crime. Again, I think you can potentially ask those questions, but I don't think a prospective board member is required to respond unless it's specifically set out in the guidelines for your community. Ken, did I miss anything there?
I think that you touched on the qualifications. In theory, it would be possible for the qualifications of a board member to include that they not be convicted of a felony in the last 10 years. But the board is not capable of making that a qualification because the statutes specifically state that the boards are not allowed to set the qualifications for serving on the board. Only the membership as a whole can do that. So it would require an amendment to the declaration or bylaws that was adopted by the full membership. And you'd have to be able to explain why this is important or relevant to service on the board. So the next question is, we ran an annual meeting a couple weeks ago and we took attendance at the beginning of the meeting. We now have an owner saying that they want their name removed from the minutes because they were not able to get a good connection. So they left the meeting after attendance was taken. If she left because she didn't have a good connection, should we remove her name? We only had a quorum with one extra person. And if that additional person had not joined, removing this one owner's name would have eliminated the quorum. What would we do in that situation where she later wants her name removed and business has been conducted under the assumption that we had a quorum? So as with many questions, the specific facts make a difference and we don't know all the specifics. So this is not legal advice, but the general rule is that under the statutes for a homeowner association meeting, a quorum is established at the beginning of the meeting only. And the quorum is considered to exist throughout the rest of the meeting, even if people leave. So if she was there, attendance taken, she established a quorum, her falling off because of her internet connection or just voluntarily leaving does not change the authority of the association to conduct business for the rest of the meeting. And that is specifically in some of the RCWs and the Homeowner Association Act at section 6438040. It specifically states that it is present in person or by proxy at the beginning of the meeting. In RCW 6490 WUCIOA, this is one of the amendments which is taking place in June of this year, is that it has been rewritten to clarify that the quorum is established for an ownership meeting at the beginning of the meeting. And so if you got a quorum at the beginning of the meeting, then you don't have to worry about it. Whether or not the person's name is or is not on the minutes is probably not particularly relevant. What we would probably suggest is that their name still be included because they were there at the time attendance was taken. If the owner objects to that at the time the minutes are being approved by the membership can vote whether or not to remove the person's name at that time, but it's not something the board has to do in advance. I do want to make sure people understand that board meetings are treated differently. For a board meeting, WUCIOA is very clear that you need to have a quorum every time a vote is taken by the board during the meeting. So if you start a board meeting with a quorum of 3 out of your 5 board members, and one of them leaves, you cannot conduct any more business because you no longer have a quorum. And so a quorum for an annual meeting for the owners is at the beginning of the meeting. A quorum for a board meeting is every time a vote is taken by the board. Anything you want to add, Lisa?
Nope, I think that covers it. Let's see, the next question. When does an invoice become part of quote unquote, all records required to be retained by a new act condominium? Is it upon receipt of the invoice or after it's been approved, paid, and is part of the financial record? The short answer to this question is an invoice when it's received. It's a record of the association as soon as the association has it. And whether or not it's paid or unpaid or put in the books or whatever you want to call it doesn't change the fact that it is an invoice and it is subject to those records, the records disclosure requirements of whatever statute you're organized under. I don't think, the statute doesn't define what an invoice is. I think we had talked about earlier, just one of the changes that the change of WUCIOA is about records. So make sure you're referencing the correct statute. They're not all the same anymore as of June. But yes, I think Ken mentioned something about what we were talking before about whether there's an accrual accounting, whether they're using accrual accounting as soon as the expense becomes an expense of the association. When that vendor is hired, it's actually shown as a liability for the association. So when the person starts doing the work. So doesn't matter whether the invoice has been paid or not, that invoice is a liability of the association and is a record to be disclosed if someone asks for it. Anything I missed there, Ken?
I would just offer, if someone was concerned about the accuracy of the invoice or disputing the invoice, all the records would include the challenges to the invoice or revisions to the invoice or the board's decision not to pay the invoice. So a part of me is confused as why you would care about the invoice being a record of the association. And then it does make me suspicious about the motivations of the board if they are trying to exclude invoices from being distributed to owners when owners request.
That may follow up with the next question.
Okay, so I guess that's my next one is for, and also, even though these questions are specific to new act condos, the records retention and records review provisions for all of the 4 community association statutes were rewritten in July of last year. So this is true for everybody. Does a unit owner's request to examine records have to be for a specific time period, e.g. legal services invoices for January through March 2024, or can it be an open-ended request such as send me legal service invoices every month? So I'm going to start with the fact that legal invoices may have protection which is different than other invoices, because legal invoices may contain the advice from an attorney, and so they are privileged and not subject to review by the owners in the same way that invoices for landscaping or repairs might be. So I don't like the fact that the question is specific to legal service invoices. Otherwise, I would offer that generally a records request is going to be for records you already have today. I don't think you have to honor a request that every time a new invoice is received, that it be forwarded to an owner. On the other hand, we are seeing a lot more associations who are making all their records available on web portals where it's just as easy to respond back to an owner that every invoice that the association has received is in the file for that month, and they can go look at it. And as long as your websites are password protected so that only your owners are able to review them, that's probably an easy way to deal with it. We did have a client, I think last week, that had a demand via an owner for every record of the association, and the response from the client to us was that they're all on their website. Now, I have a little bit of a challenge believing that every record for 20 years is on the website. On the other hand, every record for 20 years is not required to be kept by the association. And even though there are now specific requirements for record retention, the statute carved out that it only applied to records the association had as of July of 2023. They didn't have to go back and try and recreate records that they had already disposed of or lost or never received. So I guess the short answer is you don't have to do an open-ended request for everything in the future. That an owner, I think, does have to state the time period for which they are asking for past records. And the association only has to produce what's required to be held by statute and that they actually have. So I don't know if that covered everything. Do you have something else to add, Lisa?
I was just gonna say that an association could, if someone asked for a really broad request, try to narrow it down a little bit. I mean, they don't have to just dump all the documents. They can say, this is what this is going to be. Is this what you really want? Or what do you really need? I think it's okay to ask questions. And also, I think because a reasonable charge is allowed under the statute to, for copying or for time, it may be worth letting the person know what that charge might be and see if that may change their request. You'd mentioned the legal invoices, and it's the information on the legal invoice, any advice or any reference to attorney-client privileged information would be redacted, but the invoice itself still could be provided to someone. It just wouldn't have all of the line item information on it, but the amounts would potentially still be available to review.
Yes.
Okay, next question. Can the 2024 annual meeting minutes be amended with the election winners, since the election winners were not announced during the meeting until the next day? Should the annual meeting minutes say amended annual meeting minutes or draft meeting minutes? And also, will the annual meeting minutes not be legitimate and fail approval next year if they don't mention if quorum was established and the meeting notification was sent to the homeowners? So the short answer is, don't change the minutes to reflect something that didn't happen at the meeting. You could certainly have an attachment to the meeting minutes that mentioned, who the winners were when you send out the draft meeting minutes for approval. And as Ken mentioned when we were talking, it sort of begs the question of why weren't the votes counted at the meeting? It would make this all a much simpler answer that you could then just include those in the minutes because that would have been done at the meeting. So that's something to consider if you're able to do so. Go ahead and count those votes and include that in the minutes at the time they're happening. When you do send out the minutes to the membership for approval or to the board for approval, depending on the type of meeting we're talking about, this is the annual meeting, you would indicate that they were the draft meeting minutes until they were approved. Trying to think if there's anything else, questions they were asked here. If they fail to, the question is if the meeting minutes fail to mention quorum was established. I don't know that will fail the minutes. I don't know if that's the right question. The meeting minutes are draft until approved by the membership. So as long as they're approved, they're approved. You might also make a note of what kind of association you are, because there are requirements about how soon you have to do, or how soon you have to send out the draft meeting minutes. I believe it's the Homeowners Act requires them to be sent within 60 days of that meeting. And if you're waiting until the next year, those meeting minutes have not been sent timely under the statute. I think I'm jumping around a little bit. Ken, am I missing something in the question?
Well, I want to edit a little bit your last comment. It's not that you have to send out the meeting minutes within 60 days for a homeowner association. The statute says they must be made available. So basically it says that within 60 days after the homeowner association meeting, and this is specific to single family homeowner associations under 6438, that draft meeting minutes have to be available if an owner requests them. So that means that the board should, within the 60 days, have a copy of the draft board or draft homeowner association meeting minutes that the board reviews and approves for distribution if an owner requests. You can send it out to everybody if you want to. You're just not required to by the statute. You might want to just make it available online. that might be the easy way to solve some of these problems, is if you've got a website where you are posting these documents. You can post the draft minutes, you can post the election results. I think that if an owner wanted to challenge the quorum, they should be doing that promptly. They should have done it really at the meeting or immediately following the meeting. I think it's unlikely you'll get a challenge to the quorum a year later when you hold your next annual meeting. But I've seen some quirky things occur in different communities.
And Ken, didn't you mention that under WUCIOA, that 60-day availability is no longer or is not in the statute?
That's true. It's one of the things which never made it into Ukiah that was unique to the Homeowner Association Act. And at least as of the version which is effective in June this year, the 60-day requirement is not in the Ukiah statute. So that would be, if you cared about that provision, another reason to adopt Ukiah early. Next question. We have a homeowner who sends letters to the board on a regular basis, lengthy letters, arguing with every decision of the board. The board has spent countless exhausting hours responding to these. The question at this point is there a legal obligation for the board and management company to continue spending copious amounts of time responding to the communications? What are the repercussions if they stop responding? So the short answer is that you don't have to respond to every question, comment, or demand from an owner. I think that it would be valuable to at least send an acknowledgement to the owner that the board and management has received the letter, and you can say that you will consider it at the next board meeting. It's possible to adopt a communications policy, and we do recommend them for our clients, that would provide a sort of a clear process on who the owner is supposed to send letters to, what investigation, if any, the board is going to do, when it will be addressed. So, for example, if the letter arrives more than 7 days before a board meeting, then it'll be put on the agenda for the board meeting. The idea is that you want to have enough time to read and investigate and collect information so that when the board addresses anything related to a letter, the board is fully informed. You can acknowledge a letter and then simply state that the board reviewed the letter and is taking no action. And that is good enough for a lot of this kind of letter where someone is just disagreeing with the board's action. I do think that there's going to be an obligation for someone to read the letter and see if there is some specific demand or request which you are required to respond to. So, for example, if they have buried in their long diatribe about how the board should not have hired the landscaping contractor, if buried in there is a request for the records of the landscape contract and board meeting minutes where the board approved the landscaping contract, they are entitled to get those records. So the response may be is limited to, here are the records you requested in your letter to us. So that's kind of, I guess, my takeaway is read through the letter, look for any specific demand or requirement that the board comply with a statutory requirement or a requirement of your governing documents, and then address those requests at a board meeting if it's not something that the manager can just handle by themselves, like providing a record. Anything you wanted to add, Lisa?
Nope, that's it. Let's see, next question. When a yearly budget packet is mailed to homeowners in a community, does it need to include a statement about reserves? And are homeowners entitled to ask questions before they vote on that budget? What is the law on this? This kind of goes back to where we usually hammer away at least once a year on what the proper process to ratify a budget under the WUCIOA budget requirements that apply to all communities, not just WUCIOA communities. if you go to our YouTube page and look up, I think it's like budget refresher or something like that, there's an entire hour session devoted to discussing how to properly ratify a budget under WUCIOA. But the short answer to this question is yes, the budget packet must include a statement about reserves. And also, yes, the owners are allowed to ask questions before they vote on the budget. If, there should be, usually because the budget ratification is a majority of owners who would vote to reject the budget, you can ask for a motion, or if someone motions to reject the budget or something like that at the time, that may also occur. But recall that the budget packet does require a certain set of information, and one of those parcels of information is about the reserve funding of the association and what the surpluses and deficits and things like that on a per unit basis are. So that's certainly required information. It's also reasonable for an owner to want to ask questions about the budget before they approve or reject it. So certainly make time before the vote on that at your meeting to approve the budget or reject the budget. Trying to think that the statute WUCIOA specifically says that unit owners must be given a reasonable opportunity at any meeting regarding any matter affecting the common interest community or the association. That doesn't apply to everyone, it applies to WUCIOA communities, but it will apply to everyone in 2028, assuming that language stays the same. So it may make sense to just get that practice in place at this time. Ken, did I miss anything on that?
Well, I just offer that assuming we look at Robert's Rules of Order for how meetings are conducted, it is part of the intention is that there is discussion, which includes questions and answers, so that owners can make an informed decision when they vote on a matter. So you're not allowed under Robert's Rules of Order to discuss something that doesn't have a motion pending. So if a motion was made to reject the budget and it was seconded, then that would open it up for discussion, and it would be appropriate then for questions and answers about the budget before the vote is taken by the membership. And I would say that's probably true even if you didn't have enough people that you thought the vote was going to be, would fail, that they would not be able to reject the budget. And part of it is trying to, I'll say, be respectful of your members' interest and willingness to participate, and you're trying to help them be informed so that they can understand why the board would put forward the budget that they had. So it has also sort of falls into the same category as, I don't know why you wouldn't want to let them ask questions and be informed about what the board has done or why the board is doing it. Anything else, Lisa?
Nope.
Okay, so I have a general question about quorum requirements in WUCIOA versus the Condo Act. The Condo Act establishes a minimum quorum of 25%. And I'll do an aside, your declaration may require a larger quorum. Under WUCIOA, there is a default quorum of 20%. It's not a minimum or a required one. So the question is, do condos whose bylaws match the Condo Act requirement of 25% have to wait until January to amend their documents to lower the quorum to 20%, or can it be done now? Given how hard it is to get people to attend meetings or return ballots, the 5% would be helpful to our community. So I think the short answer is that unless the community wants to adopt WUCIOA today, which you can do very easily, that you would need to wait until WUCIOA is effective to amend and reduce the quorum below 25%. So the under WUCIOA, the default is 20%. It's not a minimum of 20% the way the Condo Act is written. So theoretically, you could set a quorum of 10%. I don't know that I'd want to see a quorum as low as 10%, but I certainly have some communities where it'd be difficult to get 10% given the passive nature of the membership. I don't see that so much in condominiums as I do in homeowner associations where the number of activities are smaller. Okay. So if this is a concern to you, I would suggest you look into adopting WUCIOA. There's a special provision in WUCIOA that existing condominiums can do a vote. You only need 30% of the members to participate in the vote, and you need 67% of the votes cast to approve adoption of WUCIOA, and then you get WUCIOA. Anything you want to add, Lisa?
Nope, I think that covers it. The next question, is it mandatory to mail delinquency and violation letters, or can they be sent electronically? If mailing is required, what statute mandates this? The short answer is look to your documents, look to your policies and what you're trying to do. But the question really rests on what are you sending to owners? All the statutes were changed in 2021 to allow electronic service of notices of mailings to owners if the owner opts into receiving that type of electronic notice. There are caveats to that. If you're sending a pre-foreclosure notice of delinquency under all of the statutes that is required prior to filing a foreclosure lawsuit, those must be mailed by statute to the unit and to any address the owner has given you. It may make sense if we're talking about notices or sorry, delinquency or violation letters, that you do both. If the owner has consented to opt into electronic mailing and have their email address, send them the notices that way, but there's no harm in also mailing them. But as I said, make sure you look at your collection policies. We've had a couple of associations recently where they have extremely strict certified mail requirements in the policies that have been mailed out to owners. So I would try to make sure that you are complying with the notice requirements that you have in front of you. But the short answer is if a person has consented to electronic notice, in theory, many notices can be sent to them electronically, but you may want to make sure that someone gets the notices that you're sending them. And if they're about delinquencies and violations, it doesn't hurt to send them both ways. Anything I missed there, Ken?
Well, I would also suggest, even if they have not opted in, you can still email in
Sure.
addition to mailing. The goal is to make sure that the owner receives the communication. And if we end up in court trying to foreclose on a home, one of the things that we would like to be able to say to the court is that we took every reasonable effort to communicate with the owner, which included both email and mail.
And I'll say as a collections attorney, I get a lot of owners who say, but they could have just emailed me and told me this. So that point is well taken.
And there was, there was a lot of collections lawsuits which went up into the appellate courts back in the period from about 2012 through 2020. And I know there was at least one case where the court overturned a result for the association because the court felt that the association had another way of contacting the owner, whether it was a phone number or an email, and had not tried to contact the owner. And what the court basically said was, you knew the mail wasn't going through, and you didn't even try to notify the owner with this alternate method, even though the court agreed it was not required that the alternate method be used by the court. The court found in favor of the owner because they felt like a good faith effort to notify the debtor had not been made. So you do need to be cautious. And to us, cautious means use every means of communication that you can, both email and mail. Okay. Let's see. So I guess I get the last question that we've got come in. How does a finding in a district court that does not cover Washington affect Washington state? So our assumption is what this is asking about is a federal district court decision about some kind of a legal issue and how it might affect a case in Washington state. So this is, of course, too specific for us to give a a good answer. But what we would offer is that the question about whether or not a out-of-state court decision, whether it's actually an appellate court in another state or a federal district court, has influence, depends on whether or not we have a controlling case already in our state. It depends on how close the language that's being interpreted is between our statutes and the statutes in the other states. And it depends on kind of whether the legal analysis is over the same issue, which is being addressed in our states. So the Washington Appellate and Supreme Court use out-of-state cases all the time to give guidance if there is no prior case in Washington addressing the same issue. And this is true across the country. Other states will use Washington cases if they don't have something. And, you know, the Riss v. Angel case, which came out of Washington state, sort of became the national standard for what a board's duty of care was in inquiry and use of objective information in making decisions, because it was the first time that a state Supreme Court had addressed what the duty of care was for a board in addressing issues with their owners. So federal district court decisions that address an issue will have an influence. They're not binding, but they can be influential, and our courts will look to those if the statutory scheme is similar, if they are, you know, so for example, if we're using the Condominium Act language and 17 other states have adopted the Washington or the Uniform Condominium Act language, that's 17 other states that may have interpreted exactly the same language for the same issue, and our courts will look to those for guidance. Anything you want to add on that, Lisa?
Nope, I think that covers it.
Okay.
Chelsea, did we have any questions in the chat?
Yes, we do have a couple. So the first one, is there anything in statute that requires a resale certificate for a townhome and an HOA?
So the answer today is no, because the Homeowner Association Act does not require resale certificates. But I do want to caution that townhouses are sometimes condominiums and sometimes they are under the HOA Act. And I have a lot of people who confuse the construction type with the type of community which they are. And so just the fact that you're a townhouse does not mean you're covered by the Homeowner Association Act. Under WUCIOA, there is a requirement for a resale certificate, but I also understand that that is one of the requirements which developers and some other groups are trying to get modified between now and 2028 to try and avoid having to produce resale certificates for every time a community in any one of the 10,000 homeowner associations in the state is sold. Any other questions?
Yes, next one is, if governing documents state that a special assessment requires an affirmative vote, could that supersede RCW 6438? A board is deciding whether a specific or special assessment could apply to a roof replacement to avoid the affirmative votes issue for background.
Well, I'm gonna, there's a couple potentially relevant parts of that question. One is that most of the restrictions on spending, which require affirmative approval by owners, relate to improvements, capital improvements, and additions. They do not relate to replacement of an existing component. So if you are a homeowner association, and the second issue is if you're a homeowner association, which has a separate little provision in UKIOA, then I think that the voting restrictions that require affirmative approval were wiped out. If there truly was in a condo declaration a requirement to get an affirmative vote to repair a roof, it did not get wiped out by UKIOA, but I also would be really surprised to see that as a provision in the declaration. I have a lot of confusion amongst people who believe that a new roof is a capital improvement and requires affirmative vote of the owners. They confuse the IRS's definition of a capital improvement, which is depreciated over time, with how our legislature treats capital improvements in condos, which do not depreciate their roofs. There is a court case, which is Lowry v. Allen Moore Ridge, which addressed very specifically for a condominium whether or not a replacement of windows and siding and roofing required that affirmative vote because of the language in the declaration. And the court held that it did not require the affirmative vote because replacing the siding, windows, and roofs was not a capital improvement or addition. And it didn't matter that it was better material, new material, a different type of construction, because the experts and the board had determined that it was necessary to maintain the condominium. So probably you need to get an attorney to give you an opinion on this question. Did you want to add anything, Lisa?
No.
All right, next question. Is it mandatory to mail delinquency and violation letters? The board wants to make a motion to only send notices via email to save on printing. Is this allowed if owners have not opted in for electronic consent? If not, what is the statute that mandates this?
I'll say the short answer is no.
And we just answered this question 5 minutes ago.
But if the question is, what is the statute that says this? If you Google RCW and notice and electronic, and then whatever your statute is, it'll come up. But for example, I believe it's RCW 6434.396 is the one for the new act. I think it's 64.38.110 for the HOA Act. But so if you just say, if your association is organized under 6434, do RCW 6434 electronic notice, and I think that should come up. But it does require affirmative consent of the owner to only send to them by email or electronic notice.
The statutory default is it must be mailed to the owner's address of record. It provides an exception to that default for an owner who agrees to receive electronic notice. So the answer is just no, you cannot substitute email without the written consent of the owner to substitute email.
Now, the board could certainly go to all the owners and say, we want to save money, so please sign this. But the owner could always revoke that consent later too. So, and you have to keep a copy, the actual tangible copy of whatever thing they signed or emailed to you that consents to that.
Plus, consent can be revoked because the emails are not deliverable.
All right, next. We recently discovered that the telephone lines in at least one of our 9 buildings has deteriorated to the point where it no longer maintains the signal. This is problematic with our new fiber optic internet service provider, Ziply. I do not find anything in our restated declarations that specifically calls out telephone line responsibility. Would this be per unit to upgrade on their own, or is this an association expense that we need to consider?
Well, this is far too specific a question and would require reviewing the individual documents for your community. I start to question, because of my construction background, how a wire deteriorates, but I'll just assume for a moment that the wire really is deteriorating. It's going to be a different answer for an old act condo and a new act condo, because the wire presumably is serving only one unit, so would be a limited common element under the new act. It would be a limited common element under UKIOA. And then it depends on how the declaration allocates the repair responsibility and the expense responsibility for the limited common elements. Because it may be that the pipes and wires are limited common elements and the owner is responsible for the cost to maintain them, in which case you could pass the cost for one owner's wiring back to the owner. You know, the wiring is not shared the way that pipes are shared. So there's going to be a termination point that Ziply in this case would be trying to connect to, and the wire from that termination point to the unit is all going to be exclusive to that one unit. I do have one topic I'd like to cover, Chelsea, before you go on, and that relates to the impending change to UKIOA. We get a lot of questions from people coming in about whether they're going to have to restate their governing documents because UKIOA takes effect. And the answer is you do not have to restate your governing documents. You don't have to adopt new bylaws or a new declaration. It's just that parts of them are not going to be enforceable under the new statute. As of today, I think I can say safely that 99% of the bylaws and CC&Rs and declarations which our community clients have do not match the statutes which control, and they didn't bother to redo their documents before, so there's no need for them to redo their documents going forward. You know, every statute in the state was rewritten in July last year to require records to be retained and give owners the right to review those records. Well, nobody went and revised their CC&Rs to take care of that issue, just as almost nobody revised their documents when UKIOA required the new budget processes. So associations have documents that do not comply with the statute. And this is a challenge because if you're only looking at the documents, you might miss something that's in the statute. But just as you've been able to get by without amending your documents for the last 5, 10, or 40 years, you can continue to keep your documents as they are. You just have to start understanding what the differences are in the statute and which parts of your document you cannot enforce. And there are provisions in UKIOA that allow the board to, without a vote of the owners, eliminate conflicts. So if you have a homeowner association that says there's a limit on how much the association can increase the dues every year without a vote of the owners, that was wiped out by UKIOA. You would be able to just, with a board vote, amend and re-record the CC&Rs to eliminate that provision because it is a direct conflict with the new statute. Now, you cannot make an amendment which is just allowed. So we talked earlier today about lowering the quorum for the community. Well, if you've got a quorum of 25 now and you want 20, that's not a conflict. That's just something allowed by UKIOA. That would still require a membership vote and the, supermajority requirement from your documents to amend it. So the question really is, do you want to invest money in revising your documents in order to eliminate the conflicts? Because it will reduce the number of confused owners. It'll reduce the number of times that owners are citing to you a document which they think is controlling, even though it's not. And that's a process which is relatively easy. The board can do it alone. Or do you want to try and adopt changes to your document that are allowed by WUCIOA that are going to require a supermajority? And that's a whole different process. But just because it's allowed in WUCIOA does not mean that you have to do it or that your owners will approve it. So with that, do you want to add anything on that comment, Lisa?
Nope.
All right. Chelsea, did you have any other questions?
Yes. Next question. In general, regarding WUCIOA, what are the provisions or requirements for implementing a rental cap?
So this is a provision which is just changed also in WUCIOA. WUCIOA has two ways of doing a rental cap. One is that if the rental cap is set at the industry standard for the banking industry, then the board alone can adopt a rental cap. That standard today is 50% rentals. So a WUCIOA community, the board can adopt and enforce a rental cap of 50% because that is the banking industry standard today. Under WUCIOA, the ownership can adopt a rental cap which is smaller. And under WUCIOA, as it's written today and effective until June 6th, you would be required to allow any current owner to continue to rent because the document says that you have to protect the rights of a use of a unit for any owner at the time that the restriction is put into place. Effective June 6th, that special requirement that you allow any existing owner to continue to rent is eliminated. It's one of the 50 or so modifications to WUCIOA. So it appears to be that the intent was to allow a community to adopt a rental cap and not have to grandfather all of the current owners. And so this would be a significant change and probably the second most hot button issue, because theoretically this would allow you to amend your declaration to prohibit Airbnb or to put a cap on the number of rentals in a unit, and you'd be able to enforce it, and it would not require a 90% vote the way it does under the Condominium Act today. So that would be, somebody manipulating the statute to achieve a specific purpose.
Next question. If the declaration states election of officers shall be held at the next board meeting after the annual homeowners meeting, but the board feels this will be done only in executive sessions and does so, what are any issues you can see with this decision, if any?
Well, I would offer that there's a specific list in WUCIOA of what's allowed to be done in an executive session, and an election of board members is not in that list. So I don't understand why the board would be doing the election in a executive session. I've certainly seen some boards who do even the officer elections by secret ballot, but that could even be done in, I suppose, open session still. So I would be, I'll say, not supportive of the board going into an executive session to elect the officers. I think that should be part of the open meeting.
I was just going to say that we are always talking about transparency, and this is sort of the opposite of that. And as you said, it's not litigation, not one of the other enumerated exceptions that go into executive session. So I would agree.
That is everything that came in from the chat.
All right. Well, I will talk about, for a couple minutes, two of the changes to WUCIOA, which are occurring on June 6th. They are helpful both for Ukiah communities, and I think they also would end up being a important indicator of legislative intent in the language which was adopted just in July last year for the other communities. And these relate to voting and relate to records requests. The statute for Ukiah was specifically amended to provide for secret ballots for elections of board members and secret ballots for adoption of amendments to the declaration. And the records section of the statutes were revised to include as protected records anything which would reveal how owners voted in the elections or how owners voted in the amendment process. So we had already provided to some clients legal opinions that they should not be giving out the ballots to allow one owner to see how every other owner voted in an election. And we had acknowledged that this was contrary to the specific wording of the statute. And so now Ukiah has been amended, effective in a month and 4 days or so, to clarify that the legislature did not intend for ballots to be reviewed by your neighbors. And so that's something which we think is important. It may be worth looking at some of the other tweaks to Ukiah to decide whether or not your community would like to adopt Ukiah early. We are at this point actually going ahead and advising most of our clients that if they're going to be stuck with Ukiah in 3.5 years anyway, they might as well adopt it now, because it does have some benefits like this language about the protected ballots. And it doesn't really have a lot of negatives that have shown up over the last 6 years since Ukiah was adopted. There was a lot of fear of the communities when we started, but the negatives have not really turned out. And so we don't really see a reason to avoid Ukiah. There could be some exceptions because we have a couple clients that want to retain the differences between Ukiah and their current statute, mostly related to the number of days they have to provide notice for a board meeting, because they don't want to have to go to 14 days. They don't want to have to allow open meetings, or they don't want to have to allow owner comment periods at board meetings. And so they can continue to restrict those under their current statute. It's just that protection or that option is going to disappear in 3.5 years. Did you have any other comments on that, Lisa?
No, I just see someone asked you if the blind voting provisions apply to board members.
In board meetings, I would say no, because in board meetings, you're doing voice votes. The statute specifically says that a board member is allowed to have their no vote recorded in the meeting minutes. Okay. Yeah. So
there was a very quick question, I think. Where can I find more information on the rental cap rules you just went over? Is there an RCW that I can reference for old Act condos?
well, the ones I was discussing for the Ukiah changes is you'd have to go to the bill, which everyone calls Ukiah for All. It's 197 pages long, and it has a specific section in it related to amendments of the declaration. So you'd go to Ukiah and look up amendments and get the section number, and then you have to go to the bill and look at the part of the bill which edits that section number. And I don't remember the number right off the top of my head. But if you send a question to Chelsea through info@condolaw.net and ask for it, I would get it for you next week.
Looks
right.
like we're out of time.
Yes. So thank you everyone for joining us today, and I guess we'll see some of you next week. Thank you.
Thanks.